I do have for this morning is this interesting case. It's an appeal in the Ninth Circuit. Chuck Close has sued Sotheby's, and it's a weird kind of copyright case. The appeals court affirmed in part and reversed in part. The district court had dismissed claims for resale royalties. We're in federal court, but we're under a state law called the California Resale Royalties Act. This act grants artists 5% of the proceeds of any resale of their artwork under certain circumstances. Affirming the dismissal in part, the panel held that the claims concerning sales after the 1976 Copyright Act's effective date, January 1, 1978, were covered by the 1976 Act and were preempted by copyright law, which, if you remember, we've gone over this several times, but we should go over it again. Copyright law contains a first sale doctrine where you are allowed to sell a copy of your work, or many copies, and you can set a price for those copies and everything. But once sold, you have no further rights in that copy, and others can sell that copy as they see fit. You still have copyright protection in your work, and others cannot reproduce your work, including using it on camera or et cetera, et cetera, et cetera, as like a, non-fair use purpose. But they're allowed to sell that work for a profit or for money or for nothing, or destroy it, or whatever, and you really can't do anything about that. Now, this is different around the world. In Europe, probably in Korea, probably in Japan, and I'm just guessing there, but you want to look up where there are moral rights, M-O-R-A-L, moral rights. A weird way of saying that the artist retains some rights over the artwork, those rights regarding the feel and nature of the art. So, for example, if I made a Mickey Mouse style character in Europe and I have moral rights in that character, you can't take that Mickey Mouse character and bastardize it in certain ways. You might be able to make fair uses of it, even with criticism and commentary, but you might not be able to take my Mickey Mouse character and turn him into a pornographic character for something or something like that. I'm not entirely familiar with how this works because we don't have this here in the US and I hardly ever encounter it, but there are other countries that work differently than the US. Reversing in part, the panel held that the CRRA claims concerning sales that occurred between the effective date of 1977 and the effective date of 78, so just 1977, they were not expressly preempted, nor were they preempted by conflict preemption, which is something the court will go over. The panel remanded those to the district court for further hearings. So basically, the CRRA required this 5% resale royalty, and because copyright law had this 1-year gap where there wasn't a first sale doctrine, this was allowed. And if there were sales during that year, Chuck Close would be due 5% of the proceeds. The California Resale Royalties Act grants artists an unwaivable right to 5% of the proceeds on any resale of their artwork under specified circumstances. It requires the seller of the artwork or the seller's agent to withhold 5% of the resale price and pay it to the artist or to the California Arts Council, if the artist cannot be found. If the seller's agent fails to pay, the artist may bring an action for damages. Plaintiffs are artists and their successors seeking resale royalties under the law from the statute's effective date of 1977 to present. The issue in this case is whether plaintiffs' claims are preempted by federal copyright law. The district court held that they are, as a matter of both express and conflict preemption. Preemption is when federal law trumps state law. The federal law is higher in the hierarchy of laws that overrule one another. So the federal law overrules the state law overrules the local law, the local county law overrules the local city law overrules the homeowners association. You get it? There's a hierarchy to it. What is federal law? Why does federal law overrule state law? Well, remember, we live in a country that is a federalized conglomeration of states. We have 50, almost 51 independent states, and those states all have their own rights and can make their own laws, except that they've all agreed to live together under one common set of federal laws, and the U.S. Constitution sets out what's covered by federal law and what is left to the states. Things that are not handled by Congress are left to the states, except under certain circumstances, like the Dormant Commerce Clause, where things that the federal government is allowed to regulate in commerce, states are not allowed to regulate, even if the federal government doesn't regulate them. So let's read about that here. The droit de suite. Many nations recognize the droit de suite, under which artists receive a royalty each time the original tangible embodiment of their work is resold. This makes most sense for painters or sculptors. We're not talking necessarily about someone whose work is constantly reproduced, like a music album or a YouTube video. This is more for like the original work. The practice was first recognized in France and then adopted in other civil law jurisdictions. Droit de suite literally means the right of following on. More recently, a number of common law jurisdictions have adopted some form of the droit de suite. In those countries that recognize it, the droit de suite is considered a moral right, albeit one with economic value. The droit de suite protects visual artists who face particular difficulty in capitalizing on their work. Literary and recording artists can generally profit from their efforts by controlling the reproduction of books and music. For visual artists such as painters and sculptors, however, the right to control reproduction is often not their principal source of income. Rather, it is often the sale of the original work that allows them to make a profit. The droit de suite gives these artists an economic interest in subsequent sales of their original work, thereby allowing them to capture some of its appreciation in value after the first sale. The court goes on to discuss its international copyright law origins. Since 1948, the Berne Convention has recognized that artists possess an inalienable right to an interest in any sale of the work subsequent to the first transfer by the author of the work. We have something called the Visual Artists' Rights Act, but the droit de suite provision was removed from that. In 1992, the Copyright Office issued an extensive report concluding that there was insufficient economic or copyright policy justification to adopt the droit de suite policy in the U.S. The report recommended that, given potential problems of preemption, enforcement, multiple application, any droit de suite that is enacted in the U.S. should be at the federal level. So the California law was the first and thus far only American recognition of the droit de suite, according to NIMR on copyright. In 1977, art dealer Howard Morseberg sold 2 paintings under circumstances requiring him to pay royalties under the CRRA. He then brought suit to challenge the California law on multiple grounds, including that it conflicted with the 1909 Copyright Act. To resolve this conflict preemption question, we relied on the Supreme Court's decision in Goldstein v. California. Goldstein held that a California statute making it a criminal offense to sell pirated musical recordings was not preempted by the 1909 Act because the California statute regulated a matter not covered by the 1909 Act and did so in a manner that did not disturb a careful balance struck by Congress between those matters deserving of preemption and those things that should remain free. There was no conflict between state and federal law. Applying Goldstein, we concluded that the CRRA created an additional right similar to the additional protection afforded by California's anti-pirating statute and therefore did not conclude with the 1909 Act. We expressly declined to consider whether the CRRA was preempted by the new 1976 Copyright Act. Federal Copyright Act. In 2011, plaintiffs filed a class action complaint against Sotheby's, Christie's, eBay, alleging claims under the CRRA and derivative claims under California unfair competition law, etc. The statute of limitations for that is 3 years. Plaintiffs sought to represent 2 classes, a class of artists or their estates purportedly owed royalties on sales that took place within 3 years of 2011, and a class of artists or their estates purportedly owed royalties on sales that were never disclosed to artists that took place way before, all the way back to January 1st, 1977, which is the CRRA effective date. The The district court dismissed plaintiffs' complaints with prejudice, holding that the CRRA's regulation of sales outside California violated the Dormant Commerce Clause, and that the offending portion of the statute was not severable. The Dormant Commerce Clause, as I mentioned before, means that normally anything not regulated by the federal government is left to the states. However, there is a clause in the Constitution giving the federal government and Congress the power to regulate interstate commerce. And so interstate commerce makes sense. The federal government shouldn't have control over commerce within one state that stays within the borders of one state. Point A to point B to point C, whatever, stays within the state. But the moment it crosses borders, the federal government has the right to regulate it. The Dormant Commerce Clause says that the federal government doesn't have to regulate everything and still retain its power. And if a state goes and makes a regulation on something that crosses interstate commerce, that regulation is automatically invalid. So the Dormant Commerce Clause means the states cannot regulate interstate commerce, even if the federal government has chosen not to. On appeal, a majority of this court voted to initially hear the case en banc, or I think that's when all the justices sit at the same time. Sitting en banc, we agreed with the district court that the CRRA's regulation of out-of-state commerce violated the Dormant Commerce Clause, but held that the offending provision was severable from the remainder of the statute, such that plaintiffs still had potentially viable claims respecting in-state sales. So, the out-of-state or interstate sales would be covered by the Dormant Commerce Clause, and the CRRA is invalid against the federal Dormant Commerce Clause. You will not find the Dormant Commerce Clause in the Constitution. Rather, it has been interpreted by courts over the years that that's one power that the federal government has that the state governments do not have. Now here, the appeals court is saying that the Commerce Clause or Dormant Commerce Clause applies to the out-of-state commerce, but you can separate, and the in-state sales can be covered by the CRRA. We remanded to the three-judge panel to consider defendants' alternative arguments, including preemption. That panel, in turn, remanded to the district court for it to consider defendants' alternative arguments in the first instance on remand. Defendants again moved to dismiss, arguing that the CRRA is preempted by federal law, that the CRRA affects an unconstitutional taking. Okay, that we're going to have to get into a whole other discussion about what a taking is. A taking is eminent domain, is when the government comes and takes your property. And the Constitution, Amendment 5, says that they cannot take your property without due process of law and without providing reasonable compensation. So there's lots and lots and lots of case law. What's the one in Connecticut? But the city of New London, Connecticut, I think it was, had famously exercised eminent domain over an entire town and was going to transfer the property to a pharmaceutical company, I think it was Merck, and make a whole corporate office center and waterfront. And that sounds awfully private. And the takings clause, or the takings clause of the Fifth Amendment, says that it has to be taken for a public purpose. So the court, the Supreme Court, ruled on whether or not taking by eminent domain an entire town, and in a sense giving it, I believe it was being sold, but it was still being sold at a reasonable price to Merck Pharmaceuticals or whoever the pharmaceutical company was. That was not a public purpose. So it turns out that the court says it is, that there will be a public benefit. And as long as the taking is for a public benefit, you can take.
The case was Suzette Kelo v. the City of New London.
Kelo, not Keno. Thank you. Kelo versus the City of New London. And the funniest part to me of this whole story was that although Kelo lost, the delay of the case meant that the contractor walked away from creating the waterfront and corporate property and all that. And so the City of New London, for a time, I'm sure it's bounced back by now, but the City of London for a time became a ghost town. Taking the entire city by eminent domain backfired. Why do we need eminent domain? Well, imagine that you need a new highway. Imagine you need to expand a highway or expand a railroad or install a bike path or whatever, and so you need to renovate. And imagine if there's 100 properties in the way. So you get, 100 people's information, you put your clipboards together, you go out and knock on their doors and send them letters and everything, and you get 98 of them to sign up. They'll sell you their small part of their property or whatever has to be sold to the government for a reasonable price, and everything's good. 2 of them figure it out. What do? Those 2, let's say that they're right in the center of the thing, and you can't complete the project without their properties. They figure it out, and they're like, no, I want $5 million for my 6 feet of property. And, what do? Well, the government has to have a way to solve that. And so they take the property by eminent domain. They pay you a similar sum to what they paid everybody else, and they take it, and you can't do anything about it. Fortunately, our government doesn't seem to be doing this a lot, but it has the power to, and that can be scary because I like my house. What if they just decided that they wanted this city block for something, and they just bought up my city block and that was it? And because my house isn't totally fixed up yet, what if they say that although the tax records say my house is worth $100,000, what if they say my house is really only worth 30? Do I have to go to court against them and spend my money? And then how much money do I have to spend to get back how much? Like this puts people in a terrible situation. And you can imagine this happens, to 100 people or more in a city like New London. So they, Chuck Close, argued that the CRRA is preempted by federal law, that the CRRA is an unconstitutional taking against the Fifth Amendment of the federal Constitution, the U.S. Constitution, and that eBay is somehow not subject to the CRRA. I don't know. The district court granted defendants' motion, dismissed the actions with prejudice, holding that the CRRA was preempted by federal copyright law as both a matter of conflict and express preemption. With respect to conflict preemption, the district court reasoned that the first sale doctrine codified in the 1909 Copyright Act and reaffirmed in the 76 Copyright Act provides that once the copyright owner places a copyrighted item in the stream of commerce by selling it, he has exhausted his exclusive statutory right to control its distribution. The court concluded that the CRRA restricted transactions that the first sale doctrine intended to leave unrestricted and therefore conflicted with federal law. While acknowledging our 1980 decision in Morseburg, the court held that the recent decisions of the Supreme Court and the Ninth Circuit have so eroded Morseburg that it no longer represents a binding interpretation of the first sale doctrine and the CRRA. In the alternative, the district court addressed express preemption, holding that the CRRA does no more than broaden the distribution rights granted under the Copyright Act and thus is expressly preempted by the 1976 Act. In other words, that the laws overlap and therefore the federal law will win or trump. The court noted that it's the same result whether or not Morseburg is still binding precedent because Morseburg did not address the 1976 Act. Although the court's preemption holdings completely disposed of all 3 actions, the court proceeded to consider defendants' alternative arguments. The court rejected the takings clause argument but accepted eBay's argument that it was neither a seller nor a seller's agent. Okay, so that was eBay making their own argument. Plaintiffs appealed the district court's judgment. We consolidated the appeals. Analysis. It is well established that Congress has the power to preempt state law. In general, there are 3 forms of preemption: express, conflict, and field. Because Congress has not preempted the field of copyright law, only 2 forms of preemption are at issue here: express and conflict. Below, we first hold that plaintiffs' claims arising under the 1976 Act are expressly preempted by 17 U.S.C. 301A. On or after January 1st, 1978, all legal and equitable rights that are equivalent to any of the exclusive rights, etc., are governed exclusively by this title. No person is entitled to any such right or equivalent right in any such work under the common law or statutes of any state. So this is what I believe the court is calling express preemption. The 1976 Copyright Act adopted for the first time an express preemption provision in 301A and thereby accomplished a sea change in the relative powers of the states vis-a-vis the federal government over copyright protection. The House of Representatives anticipated that the preemption provision would accomplish a fundamental and significant change in the present law by substituting a single federal system for the present anachronistic, uncertain, impractical, and highly complicated dual system. The bill would greatly improve the operation of the copyright law and would be much more effective in carrying out the basic constitutional aims of uniformity and the promotion of writing and scholarship. In accordance with 301A, we have adopted a 2-pronged test to determine whether a state law claim is preempted by the 76 Act. First, we decide whether the subject matter of the state law claim falls within the subject matter of copyright as described in sections 102 and 103 of the Copyright Act at 17 U.S.C. Second, assuming it does, we determine whether the rights asserted under state law are equivalent to the rights contained in section 106, which articulates the exclusive rights of copyright holders. With respect to the first prong, the subject matter of copyright encompasses original works of authorship fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. This includes, for example, pictorial, graphic, and sculptural works. There is no doubt that plaintiffs' claims under the CRRA for resale royalties on the works of fine art, described as original paintings, sculptures, drawings, or works in glass, fall within the subject matter of copyright. Plaintiffs do not dispute this prong of the test. The second prong is also satisfied. That is, plaintiffs' state law claims assert rights equivalent to rights within the general scope of copyright as specified by Section 106 of the Copyright Act. To explain why this is so, we begin with a short history of the first sale doctrine. The Copyright Act of 1891 provided that the copyright owner had the sole liberty of printing, reprinting, publishing, completing, copying, executing, finishing, and vending the copyrighted work. It stated that its retail price was $1, and that a retail sale of any lesser price would be treated in $1, and Bobbs-Merrill sued for infringement. The court held that Bobbs-Merrill could not control Macy & Company's resale of the purchased copies. A copyright owner who has sold a copy lawfully made under this title, or any person authorized, is entitled without authority only to the first sale of the copyrighted work, because once the copyright owner places a copyright statutory right to control its distribution. One purpose of the first sale doctrine is to effect the common burden of trying to enforce restrictions upon difficult-to-trace, readily movable goods, and avoid distribute copies or records of the copyrighted work to the public by sale or other transfer of ownership. Distribution right are not coextensive, they are equivalent. The two rights differ in that one grants downstream sales of those copies. The equivalence of the two rights is further underscored by the manner in which the CRRA both expands and restricts the federal distribution right. The CRRA expands the federal distribution right because, where the first sale doctrine limits artists' right to payment to the first sale, the CRRA grants artists an unwaivable right to a 5% royalty on all downstream sales. Indeed, the CRRA is designed to precisely alter the first sale doctrine by affording artists a right to some measure of payment on every sale after the first. And we'll skip some of their arguments a little bit. They argue that it creates a monetary, not a distribution right. The court says no, it obviously touches on distribution. Second, it can't be preempted by law because they can do it by contract, but the law can't compel the act, so the artist can do it, but the artist would have to do it by contract. Then plaintiffs argue that the case Morseburg should control the analysis of express preemption, but Morseburg concerned the preemptive effect of the 1909 Act only. Finally, plaintiffs point to the legislative history of the Visual Artists' Rights Act. In enacting the VARA in 1990, the House indicated that state artists' rights laws that grant rights not equivalent to those accorded under the proposed law are not preempted, even when they relate to works covered by the bill. For example, the law will not preempt a cause of action for a misattribution of a reproduction of a work of visual art or for a violation of a right to resale royalty. This brief statement postdates the 1976 Copyright Act by over a decade and at best represents the House's understanding, right or wrong, of how existing law might intersect with the changes proposed in the VARA. It is not legislative history of the preemption clause adopted in the 1976 Act, nor are we aware of any similar statement in the actual legislative history of the 1976 Act. VARA's legislative history does not alter our analysis regarding the equivalence of the state and federal rights at issue. In short, the CRRA falls within the subject matter of the Copyright Act and asserts rights equivalent to those found in 106.3 of the Copyright Act. The CRRA is therefore expressly preempted by 301A. Plaintiff's CRRA claims arising after the effective date of the 1976 Act are barred. The court next goes into conflict preemption. The 1909 Copyright Act contains no express preemption provision. Our holding on express preemption therefore does not account for plaintiffs' claims, if any exist, that arose between the effective date of 1977 of the CRRA and the new Copyright Act's effective date of 1978. This remaining sliver of claims is preempted only if it conflicts with the 1909 Act. Our decision in Morseburg, which likewise addressed sales of fine art occurring in 1977, is squarely on point. Its holding that the CRRA does not conflict with the 1909 Act therefore controls our analysis of plaintiffs' remaining claims. Defendants argue that Morseburg has been overruled, because neither the Supreme Court nor our court sitting en banc has ever expressly overruled Morseburg. We must look to the clearly irreconcilable test of Miller v. Gaming. In Miller, we set out standards under which one panel of this court may hold that a prior decision of the court has been effectively overruled. A prior decision is effectively overruled if intervening higher authority has so undercut the theory or reasoning underlying the prior circuit precedent as to make the precedent clearly irreconcilable with the intervening authority. The clearly irreconcilable requirement is a high standard. Accordingly, it is not enough for there to be some tension between the intervening higher authority and the prior circuit precedent, or for the intervening higher authority to cast doubt on the prior circuit precedent, so long as the court can apply our prior circuit precedent without running afoul of the intervening authority, it must do so. What the court is saying there is that the 1909 Act did not contain a written provision that expressly preempts or overrides the ability of states to create this sort of running royalty. And so the 1909 Act allows the 1977 CRRA to do its thing in California. So the long story short is that the CRRA does apply all the way through the end of 1977 for items that were sold in state and in state only. I will skip the takings clause argument. Despite being a scholar of takings law, I would absolutely love to read this to you right now, but we're going to be running way long on this story already. So in conclusion, our decision today means that the CRRA had a short effective life. California's statute permissibly coexisted for 1 year alongside the 1909 Act. Once the 1976 Act took effect, however, the balance of the state versus federal copyright protection shifted, and the CRRA was preempted by Section 301A of the U.S. Copyright Act. Thus, plaintiff at most can only state claims for the period between the effective date of 1977 for the CRRA and 1978 for the 1976 Act's effective date. We express no opinion as to the merits of plaintiff's remaining claims. So Chuck Close, if he had sales in 1977, he gets to claim 5% of those sales. And these other plaintiffs as well, because this was, I think, some kind of class action lawsuit. So there's some new copyright law for you that you probably have not heard about before on this channel, I don't think. Conflict and express preemption are actually not copyright law. That is what we call conflict of laws. And if you go to law school, you will have a whole course or whole section of a course on conflict of laws. And it is a very detailed thing. When do federal laws override state laws, override local laws, etc.?
Okay, I have a question.
Go for it.
They said, in their opinion, that this extends also to even computer-generated visuals. So would that mean that when the rights to that visual are sold, then the person gets 5%? Or how would that work, do you think?
It says an original piece, so it would have to be like the original gets sold.
So digitally selling the original, in my mind, means selling the rights to use the original. Because there is no like original copy of a digital work.
Yeah, I would. Yeah, if the act or something similar to it has survived till today, or we have something new today, yeah, that sounds like it might apply. And here's the thing, though. Let's imagine that this did not get preempted, and the 1977 CRRA still applies in California. Then any sales in California between people of a digital work like that might be covered by the law, and it might not be established like in case law. So you might have to go to court and establish via case law that this applies to digital goods. And then because it's digital and because it only applies to California, if it only applied to California, that would be really interesting, because then you have a whole industry of people wanting to cash in on that 5% by saying, hey, I'll charge you less. I'll be your straw man out of state. You transfer it to me, we transfer it back. I'll set up a whole system to do it, and you pay me 1%.
I'm also curious about how it would be implemented, because there are a lot of works where there are multiple copyright holders. So for like a video or something, it's like you have the director, but you also have the music score that goes with it, and the script has its own copyright as well. So if you were to resell a DVD, how many copyright holders would be able to claim that?
Yeah, that could be a problem too. I think that's what the Copyright Office was saying in that one section where they reported that this might not be a good thing to implement because you have to keep track of it all. And we already have what's called the orphaned works problem, where copyright owners create works and they might forget about them, or they might die and their estate might forget about them, or they might transfer them and the transferee, the recipient, the person who bought them might, move on to other projects and forget about them. And so what happens if I want to make use or license of a copyrighted work and I can't find the original owner to ask for permission? How do I protect myself and yet still be able to use the work?
Didn't that happen to you last year with a piece of software you were trying to use?
I was doing bankruptcy practice, and the bankruptcy software required Adobe Acrobat Distiller, and they don't make that anymore. You can't buy that anymore, and it required it. And it was like 5 years old at the time.
Yeah.
And I could not find a copy of it, so I went and pirated it. And I can say that now because it's been more than 3 years, and there's only 3 years on copyright statute of limitations. But yeah, that shouldn't have to happen. But at the same time, I mean, what steps have anybody taken to stop this problem? It's just kind of a thing that happens. It's just we have to account for this, an externality of copyright law. We happen to have a dog. Up, come on, good boy. We happen to have a dog here to say hi. Hello, my Nico boy. How are you? So thank you very much for joining me. I am, of course, Leonard French, your favorite copyright attorney. This is a community-supported channel. We would not be here, at least at this level, were it not for your support and involvement in the channel. We are supported through your donations on patreon.com/ljfrench, and really appreciate all of your efforts and, like I said, involvement, suggesting stories, interacting with me and the Discord channel helps us understand what stories you're interested in. So thank you very much to all of you who support the channel, starting with Kareem Harper, our $500 supporter and video sponsor for July and the previous 3 months. And thank you to our $50 supporters, Jonathan Doe, John Steele, Gavin Barnard, Evie, Andy, Kyle Mudrock, John H. Anderson, Vera Montaigne, Sean McNamara, William Gonzalez, Michael Pierce, Terry Crisp, and Grunkle Tia Marie. And thank you very much to the $5 plus supporters. There are about 210 or 15 of you. You're scrolling on the LED panel behind me, and you'll be on the screen as well when we do any of the VODs. And it's amazing that we have this level of support. In all, there are 440 Patreon supporters. I'm absolutely floored that this is what I'm doing for a living right now, and this is really cool. Thank you very, very, very much from the bottom of my heart for this opportunity. There you go. Thank you everyone for joining me. Have a great Sunday and a great week. I'll see you on the channel. Bye.